Petition 1458 on the Register of Interest for Members of Scotland's Judiciary. Our second agenda item is evidence on Petition 1458 from Professor Alan Paterson. As members will recall, the petitioner suggested that the committee may wish to invite oral evidence from Professor Paterson, and he has agreed to appear this morning. And I'd like to welcome you to the meeting. We appreciate your attendance. I wonder if you'd like to make any opening comments, and if so, I invite you to do so for up to about 5 minutes. And after that, we can take questions from members.
Well, thank you, Convener. I'm happy to answer any questions that I can to the committee on this topic. In terms of a preliminary statement, I would say that I see the issue of a register of interests for the judiciary in Scotland as an important issue, but an issue on which, as I said in my written evidence, I haven't reached a concluded opinion on. Where I have expressed an opinion is in relation to the Supreme Court, where I think that the balance probably tips, in my view, towards there being a need for a register of interests. And I've explained why I think that in my written evidence and in the lecture that I gave, the Hamlin lecture, where I said that. For me, the question of register of interests comes back to the role of the judiciary in a democracy. It's a branch of government of the state, and in a democracy we expect wielders of state power to have a form of accountability. But it's very important in relation to the judiciary in a democracy that they are also independent, and judicial independence is a vital part of any democracy. So you have to balance these two issues, judicial independence and accountability. So issues such as recusal or criticism of judges, discipline of judges, complaints against judges, or a register of interests are all areas where we try to draw the balance between accountability and independence.
Thanks very much for that. Do you think there's a third factor, which is just simply transparency, that is not in conflict with independence, but just kind of, basic standards of reasonable expectations of openness?
I think transparency for me is part of accountability. Well, in terms of accountability in judges, the prime things we require are the judges give reasons for their decisions, and that we expect them to identify who the judges are who are making the decisions, generally speaking. That's part of transparency. So the question of a register of interest is all part of the issue of transparency.
Okay, and do you have a particular view on what types of information should be included in a register of pecuniary or other interests, even in the terms that you've...
Well, if you're going to have a register of interests, as I said, I don't have a concluded view on that as far as the Scottish courts are concerned, but as far as the Supreme Court is concerned, we have the example of the American Supreme Court, which some might say is slightly more political a court than some of our courts, but nonetheless they have to have a register of interests, and they have to declare their financial interests, their shareholdings, their hospitality, what gifts they get, what tickets to American football matches they get, and all sorts of things have to be declared, and membership of golf clubs and so on. And they also, at the start of their career as a Supreme Court, have to sign up a detailed account of what clubs they're members of, what trustees they're members of, and whether they're Masons and all those issues. And the system works. From time to time it throws up issues, but it can work. Now, in the House of Lords, when it was the precursor to the Supreme Court, because the Supreme Court started in 2009, but before that it was the judges in the House of Lords that were the Supreme Court. They had a register of interests, and the judges who were members of the House of Lords then became Supreme Court judges, for example, Lord Hope of Craighead. Now that he's gone back to the House of Lords, he has a register of interests, and you can look it up on the website and you can see what his interests are. But when he was on the Supreme Court, you couldn't. For me, I think the Supreme Court has been very good at transparency, rightly so, much better generally at transparency than the House of Lords was, much more open. All the proceedings are televised. When the Brexit judgment comes down on Tuesday, we'll be able to see it. You'll be able to watch everything happening. But they just don't have a register of interest, but they had before. And if they go back to the House of Lords, some of them, they'll have it again. So.
Interesting. Okay, thank you very much. Maurice Corey?
Yeah. Good morning, Professor Alan Paterson. One of the issues that has been raised in previous evidence is that whether a register would capture the circumstances in which a conflict would mean that it would not be appropriate for a judge to hear a case could arise. For example, a judge may only become aware of a conflict at the point of seeing a witness list and identifying a social relationship with a witness. Could I ask you of any views on that?
Well, the judicial oath and the judicial code of conduct, which are very important in Scotland, means that if you know you've got an interest, i.e. a relative is going to appear before you, then at least if they're parties in the case, you'll be expected to step down. But occasionally, a register of interest, if you had one, at its highest would identify some conflicts which would either remind you or alert others to the fact that you have a potential interest. Not so much necessarily on relatives, but one of the curiosities about the American Supreme Court is about once or twice a year, the justices, including the Chief Justice, overlook a shareholding that they have and a corporation in which these shares are in comes up in a litigation, and they get involved in the litigation, and then somebody suddenly remembers, oh, you've got shareholdings in that. And it's not venal, it's not deliberate, there's no attempt at bias. It's, oh, they made a mistake, they overlooked it. So the strength of a judicial register is it allows fair-minded, independent, external observers to say, haven't you got a potential interest here? And the matter can be aired before the case starts. If you don't have a judicial register of interest, then it's all left to the judge and the judge's memory. And even at the American Supreme Court level, occasionally the judicial memory fails. Not very often.
Right. Okay. Thank you.
Thank you, Convener. Good morning, Professor Paterson. I wonder if you could expand a wee bit on examples of judicial officers registering their interests in connection with other roles. The petitioners noted this in connection with the Board of the Scottish Courts and Tribunal Service, and you mentioned the Supreme Court. Are you aware of any issues that have arisen for these office holders in being able to hear cases in connection with their registered interests? I mean, what precedents are there in that field that you know of?
I'm not sure I have an answer to that question. I'm not sure what the petitioner was getting at. Do you know? Could you elaborate a little more about what was troubling him? Because nothing immediately springs to mind. But.
Well, I think he just raised the whole subject of the connection, with the Board of the Scottish Courts and Tribunal Service, and you've mentioned the similarity between the Supreme Court and former law lords. So, really, just trying to tease out what issues could arise from that, in your opinion.
I'm apologising for being unhelpful. Nothing immediately is springing to mind about that.
No, that's fine. That's fine. It's just if you were able to tease out a bit further. Thank you.
Brian Whittam.
Good morning, Professor Paterson. A former judicial complaints reviewer commented on the possible implications of the publication of recital information in respect of possible conflicts of interest only becoming apparent after a case had been heard. Her view was that a register of interest could avert complaints by enabling any perceived conflicts to be addressed before or at the time when a case is heard. Can you perhaps elaborate on that and maybe give us your views?
Well, let me go back to the House of Lords Supreme Court. One of the reasons that I raise an eyebrow at the stance of the Supreme Court on this is that one of their shakiest moments was the General Pinochet affair. General Pinochet came to the UK for medical treatment, and a Spanish judge, using appropriate international processes, arranged for him to be arrested for alleged crimes in the junta in Chile. And his case went up to the House of Lords, and at relatively short notice, the membership of the panel that was going to hear the case had to change, and Lord Hoffman was brought in as the next most senior judge. Lord Hoffman's wife, I understand it, worked for Amnesty International in a capacity, and that, we think, was known about by the senior law lord when organising the panel, but it was all done with some haste, and it's not at all clear that they were aware, and they say they were not aware, that Lord Hoffman himself acted on a committee that raised funds for Amnesty International. And why was Amnesty International relevant here? Well, Amnesty International has views about torture, and it had asked to become an intervener on the House of Lords, and it was the very first case in which an intervener had been allowed. So they weren't technically a party, but they were allowed to address the court on issues to do with torture and what had happened in Chile, perhaps. And so Lord Hoffman did not declare that he chaired a committee that raised funds for Amnesty International, although, as I understand it, his wife's position in working for Amnesty International was known to the authorities. Anyway, the case went ahead. The vote went 3-2 against General Pinochet, and with Lord Hoffman in the majority of the 3-2. A little while later, General Pinochet's lawyers discovered that Lord Hoffman had this interest, had not declared it, and therefore asked for a rehearing. It had never happened before. And they got a rehearing, and the court was very strong in saying that Lord Hoffman should have declared this interest, and indeed, as I read it, even if he had declared the interest, the parties could not have waived it. It was an automatic disqualification, which I'm not... Anyway, that's the line they took. They then had to convene another court to rehear the whole case. This involved a lot of time, a lot of concern, a lot of bad publicity for Britain and for the House of Lords. And relations amongst the judges in the House of Lords thereafter were quite strained for a number of years. So that one failure to declare an interest had a very substantial impact on a whole variety of issues. And I've never quite understood why the Supreme Court, knowing that lesson, which was, you know, hardly 10 years old by the time it was set up, did not decide that they should have a register of interest. You can have a debate about whether the register of interest would have caught the chairmanship of the committee, but I think it would certainly under the rules that the House of Lords now operates. And if you want to see a possible model, it's not a entirely appropriate model, but if you want a possible model of what a register of pecuniary interest would look like, you can look on the website of the House of Lords, where it has a very detailed series of 12 headings under which you can record things. Not all are appropriate for judges, but some of them certainly are.
I think the second point about Lord Hoffman's interesting, that it was actually his own involvement, but a spouse's occupation, wouldn't go in a register, would it?
Possibly not, but as I understand it, that wasn't that was known about.
Yes, that wasn't the issue.
That's my understanding of the case.
That's very helpful, thank you. Angus MacDonald.
Okay, thanks, Convener. Good morning, Professor Paterson. The example that you've just given backs up your suggestion in your written submission that the decision on recusals should not be taken by the judge who has been challenged. I wonder if you could maybe expand a little more on that.
Well, again, that's an area where I haven't got a fully formed mind, but what I would say is that I think that as far as appellate courts are concerned, I think, like the author Grant Hammond, who has written the classic or the standard work on judicial recusal, I take the view that on appellate courts there would be an argument for saying that if one member of an appellate court is challenged, that he or she should not be the one that makes the decision. But that may be the counsel of perfection, and when it comes to the sheriff in a rural part of Scotland, it would be perhaps quite impractical to suggest that another person makes that decision. So, as I say, I don't have a concluded view on it. I can see the case for it, and it's easier at the appellate level. And I think there have been examples where courts have, when challenged on a particular interest, excluded that interest from the body deciding that interest. And I can see the argument for it. But there are issues of practicality to be borne in mind.
Okay, staying with the issue of recusals, could I throw a hypothetical example at you? Say, for example, the son of a judge is the litigation solicitor for a defendant in a case at, say, the Court of Session. However, the judge fails to recuse himself and fails to highlight the family connection to all interested parties. Now, clearly, a situation like that could be avoided if the decision on the recusal hadn't been taken by the judge himself, the judge who is presiding over the hearing. Clearly, we would look to avoid any situation like that, and the register would help.
It might. It would be the High Court, I think, if it was a criminal defendant. But I think it would be known, generally speaking, to the parties. In the past, it was not unknown for an advocate who was a relative son, daughter of a judge to appear before that judge. In a small country like Scotland, it's a bit tough to say that can't happen, but it used to happen. And, as long as everybody knows about it and it's declared, it's not an automatic disqualification. And usually speaking, in those situations, the parties would all know, and no comment would be, no objection would be made.
Okay, thank you.
Maurice Corrie.
Thank you. Professor Paterson, what consideration have you given to the potential for additional costs or delays to cases being heard if the recusal system were to be developed in this way?
Well, that's one of the things. You're right. That's why I raised the practicality issues. Recusal is one of these areas where you have to draw an appropriate balance between transparency, accountability and independence. And there is a risk that, with recusal, we have a register of how often judges are recusing themselves, but as I've pointed out, we don't know how often they're not refusing themselves, so we can't form a view as to, is that the exact, have they always got it right? Are there situations where maybe they didn't get it right? Because the test to be applied is whether the fair-minded, fully informed, independent observer would think there's a possibility of bias. It's not whether the judge thinks there's a possibility of bias, it's a question of whether an independent, fair-minded, reasonable observer, probably a layperson, would think that there's a possibility the tribunal might be biased. And therefore it's possible for a judge to take one view and an independent position might take a different one. But I don't... That's why recusal is an issue that we have to look hard at. Do I think a register of interests, certainly at the appellate level, would lead to massive numbers of challenges that could lead to real problems? If one introduced the system whereby somebody else had to decide that, I think it might. So that, I think, as I've said, I think practical considerations may make my counsel of perfection about, in the ideal world, somebody else would make the decision unrealistic. I think it's more possible at the appellate level.
Can I ask a further sort of supplementary to that? Are there any examples you're aware of, serious examples, where this sort of judiciary abusal has actually been a real cause for a problem, which would then necessitate this going forward to be set up?
Well, the Hoffman case is a standard case of what went wrong. No, it's not. There are from time to time challenges to the courts which are which receive a degree of publicity, and I'm not aware of any that were as significant as that particular one.
Other questions? No. Can I thank you for that then? We need to look at what we would now suggest that as a committee we might want to. And thank you for your evidence. I think that's been very helpful and very balanced. I think it's been really quite an interesting insight into the issues. I don't know if the committee has a view on what we might do further. Angus?
Yeah, I think, Convener, given the evidence we've heard this morning, we need a further response from the Lord President, Lord Carloway. I, for one, would like to hear his views on today's evidence, whether that be by letter or in person. I'm particularly keen to hear the Lord President's view on whether the decision on recusal should not be taken by the judge who has been challenged or who has the specific interest that's been challenged. So it certainly adds another suggestion into the pot that is well worth looking at.
Okay, and we can look at how that response is given the most convenience. We're not want to create an unnecessary inconvenience.
We're not just going back to the previous question, we're going back with something new.
Okay, anything else that we might do?
That's happy with.
Not happy with that.
Okay.
There's also a suggestion that we ask the Judicial Complaints Reviewer for her view on any evidence that might have been given today. I think that's also. I think we should go down that route as well.
Okay, well, if that's agreed, I think there's a number of actions there. Okay, thanks very much. And again, can thank you very much, Professor Paterson, for coming along today. That's been very helpful. Thank you. And can I suspend the meeting just for a couple of minutes till we change over?